SJC-13625 in the matter of an impounded case.
Okay, Attorney Russell.
Good morning. Good morning, Your Honors. May it please the court, Lauren Russell for the juvenile appellant. Children accused of committing delinquent acts admit to sufficient facts and agree to abide by conditions of probation imposed through a continuance without a finding for a variety of reasons. Among others, to secure their release from the Department of Youth Services, or to be able to return to school, or to protect their parents from having to attend multiple court dates leading up to a trial date. Through that process, they do not admit guilt, and a judge does not determine guilt, even if a judge scrupulously honors the procedures required to protect the validity of the waiver of the rights they're making.
Counsel, could I press you on something?
Sure.
So in Wallace W., we said if this was after a delinquency adjudication and there was a quaff, that it would count, right? So all of those, the parade of horribles that you just described, that wasn't this case. This case was on for trial. It was on for bench trial, right?
Well, first it was on for arraignment.
No, the day of the quaff, it was on for trial.
It was on for an arraignment when the quaff had already been dismissed. A quaff.
I'm talking about the quaff at issue, the one when he was 16. It was on for trial.
I actually don't know that. The carry wasn't clear to me on that fact.
Did you listen to the colloquy? Did you listen to the proceeding?
I did not. The Wareham juvenile court case that resulted in a quaff in June 2022, I did not listen to.
That's the one we're talking about, right?
Well, all that was known when my client was faced arraignment for a minor misdemeanor 18 months later, all that was known to anyone was that he had a quaff on his record, and I don't think there was any information provided to the court by the Commonwealth, which was the party
But
asserting
at least
jurisdiction.
as we're sitting here today and trying to resolve this case, don't we have to look at what happened with that prior quaff?
I think that this court should set a rule for what to do when a carry is before the court, which is really all that will most likely be before the court when the Commonwealth moves for arraignment on a minor misdemeanor.
Okay, well, let's say I disagree with you, but let's just talk about the quaff. Okay, so he was on for trial, and prior to bench trial, the Commonwealth and the juvenile's lawyer come in and say, we have a disparate tender on disposition, but we have an agreement as to the index quaff. And in Wallace W., we said, if that matter had gone to trial and he was found adjudicated delinquent, and the court, after the delinquency finding, imposes a quaff, that would count for Wallace W. purposes.
Yes.
Why is it that it makes any practical sense that because it happened a half an hour before, where during the course, and I know you dismissed the procedural safeguards, but during the hearing, his mother's there, he's represented by counsel, the juvenile court judge goes through all of the important constitutional rights that he's giving up, his right to be convicted by a jury unanimously or a judge, his right to cross-examine and confront the witnesses, his right to present his own defense and testify in his own behalf. She gave all of the things, and importantly, the Commonwealth read into the record what they would have proven had the matter gone to trial, and he had to allocute to that, and he does allocute, and says that he agrees with the Commonwealth's recitation of the facts underlying the assault and battery. Why isn't that tantamount to what we said in Wallace W. has to be proven beyond a reasonable doubt? Because he could be found guilty on that allocution.
Well, I think if that was the stipulation that was made, I'm not sure that that's an admission to sufficient facts. An admission to sufficient facts is by definition not an explicit acknowledgement of guilt. As someone who's practiced in juvenile court, I've seen an awful lot of admissions to sufficient facts that proceed by the prosecutor reciting the facts that they anticipate being able to prove at trial, and the juvenile being asked, do you agree that if this case went to trial, you could be found delinquent? And the juvenile, by saying yes to that, is not stipulating to the truth of the facts, is not saying that he wouldn't have a defense that he would present at trial. He's saying that he's waiving the right. One of the rights that Your Honor did not mention is the right to be convicted based on proof beyond a reasonable doubt. So he's waiving that right by tendering a plea.
And he agreed to that.
Right.
He
but
agreed in
he's
the colloquy.
But by waiving the right to proof beyond a reasonable doubt to this charge, one cannot be waiving their right to jurisdiction on a future charge. Jurisdiction can't be conferred through waiver. So in Wallace W., this court said that proof beyond a reasonable doubt is critical. And when a quaff follows from a trial verdict or a delinquent plea, where the stipulation is not, I agree that if this case went to trial, I could be found delinquent, but yes, I agree that those are the facts. I stipulate to the truth of those facts alleged by the Commonwealth during the plea colloquy. That's a different story. That's not a quaff after an admission to sufficient facts.
Well, at least as a practical matter, help me with this then. The whole point that we've said in Wallace W. in the criminal justice reform was, we didn't want juveniles, because of their impetuous nature and the fact that their heads aren't fully formed, their cognitive abilities, that we want to be able to give them a strike, essentially. And the whole point of that is that they get enough of a taste that they say, I never want to come back here. And in this case, the index case we're talking about is an assault and battery with a slap across the face of the victim, which is what was read into the record during the colloquy. He's 16 years old, and we say, okay, then that for purposes of don't come back, let's just assume for the sake of argument. But now he's back. Now he's back. He's back on this 2-count delinquency complaint, and that prior case was adjudicated with this colloquy. It was on for trial for this colloquy. Why does that fit with what we said was the policy rationale behind Wallace W., where he got everything he was supposed to get,
Right,
the
and-
taste?
And Wallace W. himself also had multiple charges.
Sure.
Very similar, actually, the record was very similar to my client's when he came in. And again, probable cause wasn't enough. Proof beyond a reasonable doubt was required. And proof beyond a reasonable doubt is supplied when a quaff enters after a delinquent plea, which is what this court said in Wallace W. But a quaff entered after an admission to sufficient facts is different. It's
But
not.
why is it different? That's what I'm getting at. Because in this case, if we were to go back, it's a one-witness case, and I'm not going to hazard how long the Commonwealth would have put their case on, but I imagine the thing would have been 45 minutes. So if you're telling me that we put one witness on to testify to X, Y, and Z about the slap, because the recitation of the facts was about 30 seconds long. So you're saying as a practical matter, Wallace W. would apply after a half an hour of somebody testifying to a slap and the court finding delinquency and adjudication on delinquency, but because it happened before, when we go through all of the important constitutional rights he's waiving, and we go through the recitation of what the Commonwealth would have proved, we go through all of the immigration consequences, we go through all of the waiver of motions to suppress, and after all of that process, it doesn't count. Why does that make sense?
Because in the case of a trial, he's had the opportunity to present a defense and to challenge the evidence. And in the case of a
Knowing intelligent waiver of that right,
Yes.
it's not enough?
right, because he can waive the right to that in order to dispose of the case without a continuance, without a finding.
Okay.
And
If-
that's
Can I-
different.
Go ahead.
If we were to accept your position, I'm having a hard time understanding why the relief would be, as you suggest, to vacate the adjudication of delinquency on the disorderly conduct charge. Why wouldn't it simply be to remand for a Wallace W. hearing with respect to the earlier charge, the quaffed charge?
Well, I think it's, I don't know that it's mutually exclusive in that I think that the Commonwealth could still proceed if they elected to retry my client for the disorderly conduct
Not
charge.
retry, he's already been tried once. I'm saying, why wouldn't we just remand and say, now you have a Wallace W. Inquiry hearing with respect to the earlier quaffed charge.
Right.
At the conclusion, let's say for all the reasons Justice Georges has pointed out, judge determines, there was evidence beyond a reasonable doubt that that earlier offense had been committed, and the delinquency adjudication on the disorderly conduct would stand. I mean, I don't understand why that wouldn't be the proper relief, even if we were to accept your argument.
Well, I agree that there would be the Wallace hearing on the continuance without a finding case. The Commonwealth, I think, could either establish that it did follow from a delinquent plea by listening to the transcript and proving that there was a stipulation to guilt beyond a reasonable doubt. In that
So
case,
why
he's not
isn't-
entitled to a
okay,
Wallace hearing.
So why isn't all of the procedure and protections that accompany the a dismissal accompanied by a quaff, accompanied by an admission to sufficient facts, why isn't that essentially the functional equivalent of a Wallace W. hearing?
Well, I think to establish whether a quaff flowed from an admission to sufficient facts or a delinquent plea is somewhat functionally equivalent to a Wallace W. hearing. I think that at a Wallace W. hearing, the Commonwealth could choose to prove beyond a reasonable doubt the allegations, or to prove that this particular quaff came through circumstances that themselves supplied proof beyond a reasonable doubt, which would be after a trial verdict or after a delinquent plea.
Isn't it going to be the same thing, though? Because we've said was it Nicholas N., that the rules of evidence don't apply to strictly to the Wallace W. Here we have admission to all the sufficient facts. So
Right.
Isn't it going to be sort of pointless redo? And let me add another layer to it. After Wallace W., the first offense of a minor misdemeanor should not be even quaffed, right? It should just be dismissed. There's no jurisdiction. So we shouldn't have any of these things going forward.
Well,
These
there
are
could still
sort of
be-
historic relics, right?
I don't think so, because there could still be quaffs on major misdemeanors or felonies in a client's past, which could be the alleged predicate for a minor misdemeanor.
I got you. Okay, so that's how, it would be quaffs on major misdemeanors
Right.
that this would come up
Going
on.
forward, I think that's right. And I think that most quaffs, I think, at least in my experience, many continuances without findings have flowed from admissions to sufficient facts, not delinquent pleas. So I don't think that it's going to be.
Say that again? You lost me on that. Go ahead.
I said that in my experience, most quaffs that are entered when there's a plea. They're entered after an admission to sufficient facts, not a delinquent plea. The question is usually framed as an admission to sufficient facts, and the juvenile, and that's what results in a quaff. So I don't think that it's going to be like the majority of cases going this way.
Well, knowing again that you didn't say this, but I have communicated my request to the clerk, because it should have been in the record. But I did get the hearing and did listen to the hearing, but a transcript of the hearing wasn't provided, and neither was the tender of plea, which it should have been. So assume for the sake of argument that we follow what you just said a few minutes ago. If we were to look at what would be in front of a juvenile court judge or whomever would be holding the Wallace W. hearing, why can't we look at the plea, listen to it, look at the tender, and make the determination as to whether or not it was tantamount to a Wallace W. hearing?
I think that would be sweeping under the rug a jurisdictional defect. I think he had the right to jurisdiction during the proceedings, and by everyone in the room missing, unfortunately, that this included a minor misdemeanor in this multi-count complaint, there was not jurisdiction. The proceedings and the judgment that resulted are void. So I don't think that can be fixed at this stage in the manner that Your Honor suggests.
Even with the carrier knowing what in order for the quaff to have been entered, again, I know you say that the procedural safeguards aren't enough, but we know that the procedural safeguards are in there, or at least we can infer that they're there from the carry because the quaff entered. That's not enough?
No, I think that it would have to happen in the juvenile court in the first instance. And I think that if the court found that he was not entitled to a Wallace hearing, I don't think that the trial that preceded is enough. I think he's entitled to a retrial.
Why not? Can you explain that? Because the jurisdiction of the juvenile court is over a delinquent child. The Wallace W. hearing is just a way of figuring out whether or not the child qualifies.
Right, and he was not alleged to be a delinquent child when he went to trial.
Whatever the allegations may have been, isn't it enough to fix it post hoc?
No, because I think he
To
had
make the determination as to whether or not there was jurisdiction? Because if there was jurisdiction, this was not the first minor misdemeanor, then the court had jurisdiction the entire trial,
Well, but
regardless of whether they did the Wallace W. The Wallace W is just a mechanism for figuring out whether or not the juvenile court had jurisdiction.
Right. I think that in many instances, it's not going to be perfectly clear, so that the juvenile should have the opportunity to present evidence on this case.
I'm just wondering about Justice Wolahojan's suggestion that the remedy here is a remand to determine, to have the Wallace W. hearing to determine if that first quaff was could be proved beyond a reasonable doubt.
Right. I think it's to dismiss the disorderly conduct count as it stands now and allow the Commonwealth to either conduct a
Yeah,
Wallace
so
hearing.
that's my question. Why would one dismiss the count now?
Because the judgment that results from proceedings conducted without jurisdiction are void.
Right, so the question is, was there jurisdiction? If there was jurisdiction, because one can prove beyond a reasonable doubt that the first quaff entered, then the whole conviction is fine.
Right, but I don't think there's the answer to whether or not there is jurisdiction can be answered without the juvenile having an opportunity to present evidence to the juvenile court judge.
That's why you'd have the Wallace W. hearing.
Right, at the Wallace W. hearing.
But it doesn't have to happen before.
No, I think that if the Commonwealth established and there was no dispute that the adjudication, that the quaff entered after a trial, verdict, or a delinquency plea, then there would not have to be a Wallace W. hearing. In any other circumstances where there's any lack of clarity about how the quaff arose, then there should be a Wallace hearing and the juvenile should have the opportunity to present evidence. And if it's determined that the Wallace hearing should have, or that there was proof beyond a reasonable doubt for the predicate offense, I still think that the disorderly conduct charge should have a retrial if the Commonwealth is moving ahead with that.
Why?
Because I think that the proceedings were, I think it's sweeping it under the rug otherwise.
No, I think with all due respect, there was either jurisdiction or there wasn't. The problem you've brought to us, the way I understand it, is that that inquiry was not made. But if there was jurisdiction, then there's no problem with the delinquency adjudication on the disorderly conduct charge. If there wasn't jurisdiction, then there was. But that question needs to be answered somehow. It seems to me either we could say, as a matter of law, a quaff prior to an adjudication of delinquency that never qualifies. We could say, as a matter of law, an adjudication of delinquency, a quaff prior to an adjudication of delinquency always qualifies. Or we could say, and is, let's say, the functional equivalent of a Wallace W. hearing, or we could remand for a Wallace W. hearing. I think those are the three options, unless you can think of one other one.
No, I think that's right.
Counsel, can you give your best answer for why the legislature would not consider a quaff of the type of your client's to be a prior offense, while at the same time your client could be sentenced on that offense and actually be sentenced on that offense without anything further?
Right, I think once if a quaff upon a violation of probation, if the quaff was converted to a delinquency adjudication, I think it may be a logical corollary from the Wallace decision that would count. I also think there's some tension because there's no additional proof beyond a reasonable doubt to get from the quaff to the adjudication, as Your Honor has stated.
But again, going forward, you're not going to have that. If it's your first offense and it's a minor misdemeanor as opposed to a major misdemeanor, right? It's going to be dismissed. We aren't going to have quaffs on those, right? Mm-hmm. They're supposed to go away. So we're really only dealing with major misdemeanors, right? And historic pre-Wallace W. type of findings, right?
Right, this would be if a major misdemeanor or a felony were to be continued without a
Can I ask
finding.
a question? Is an assault and battery, I should know this, I don't. Is an assault and battery, the quaff he has, was that a major or a minor misdemeanor?
Major misdemeanor.
Okay, so that's fine. Okay, I
Yep.
got you. Okay.
Okay,
If there are no further questions, I'd rest my briefs. Thank you.
thank you. Okay, Attorney Moriarty.
Good morning. Your Honors, may it please the Court, Eileen Connors Moriarty, for the Commonwealth, Assistant District Attorney from the Cape and Islands District Attorney's Office in charge of the Juvenile Court, and joined at council table by Elizabeth Sweeney, Chief of Appeals for the Cape and Islands District Attorney's Office. In addressing the issues here, I want to direct you back to the guiding principle of the law that governs the Juvenile Court, 119, Section 53, that talks about the care and discipline of children before the court should approximate what they would receive from their own parents as far as practical, and not as criminals, but as children in need of aid, encouragement, and guidance. The criminal justice reform in 2018 came out and said that children get a first chance. The cases that have come from the court, Wallace and Nick N, also talk about the importance of the fact that repeat minor misdemeanor offenses are intended to be prosecuted for both the protection of the public and for rehabilitation of the juvenile, and also that it's important that such proceedings occur in a timely and efficient manner. The question that comes here today is whether or not a quaff counts, and I would suggest to you that that the Commonwealth agrees with the central purpose of that legislation and court decisions, that it's to preserve the juvenile's right to a second chance. And for those reasons, suggesting that a quaff doesn't count does in fact the opposite. It's important that we have progressive discipline in regards to dealing with our children. Making quaffs not count would go against the spirit of that and would make them harder to get, would make them more akin to something like pretrial probation. Quaffs are good for kids. They understand. They understand incentives. They understand that if you go ahead and do what was asked of you, that could be dismissed. That's the difference for a juvenile between.
But at least here, the issue isn't necessarily whether quaffs count. It's when you get the quaff. And so the discrete issue here is there, I guess my question listening to your sister's argument is there nothing to be made of all of the rights that the juvenile waives during a predispositional quaff versus a postdispositional quaff? Because your sister seems to suggest that it's of no import that he waives his right to counsel, to trial. He waives his right to present evidence in his own behalf. The Commonwealth gives a recitation of the facts they would have proved at trial. He admits to that. And in this case, I believe the judge asked him specifically, do you agree that that happened? And he says yes. And it seems to me that if the Wallace W. standard of beyond a reasonable doubt, that this is it. That he's saying you could find me guilty beyond a reasonable doubt, but the court doesn't enter guilty or a delinquency adjudication against him.
I agree. I would suggest that it's Mass General Law 278, Section 18, that says that the plea for a quaff and a delinquency or guilty is essentially the same, and that by entering into that plea, he had the functional equivalent of a Wallace hearing, and that's what governs. And that's what's in the best interest of the children for understanding the process and not retrying and going back through things they've already admitted to.
What do we do with all our jurisprudence that distinguishes these admission to sufficient facts and says they're not convictions? Does that matter? What do we do with all those cases?
It matters, but it's different. The juvenile court is a creature of the legislature, as the juvenile's brief points out. And it's different. It's different than everything else. So it's not that we're saying that doesn't count. We're saying for these circumstances, in this particular situation, this is the best way to do it.
Again, it should only apply to a major misdemeanor. It shouldn't be a minor misdemeanor, because again, the minor misdemeanor should be dismissed without a quaff, right?
Well, but that's only the first one.
First minor misdemeanor should be dismissed without a quaff. We don't want to use this as a work around the statute, right?
Correct.
Right.
I would agree. It's the first minor misdemeanor is going to be dismissed on its own, on its face. It's going back, but I do think minor misdemeanors, quaffs, and minor misdemeanors should count, because it's going back to the language in Wallace and Nick N that talks about repeat misdemeanor offenses. This whole, second chance that was created by the legislature is wonderful, but what they did was they inserted it into the middle of the system from the way I see it, because when the police, if there's an incident and the police get involved, the police can charge or not charge. They can file a complaint. The clerk can issue that complaint or not issue that complaint. Then the district, in some counties, district attorney's offices have diversion. We have that on the Cape. We can go ahead and divert them. If we choose not to divert them, the judge can, through the criminal justice reform, now we have pretrial judicial diversion that is prior to arraignment. Then when a case comes forward, then we can give it pretrial probation.
Right, I understand the generalities, but it's Justice Wolohojan's question that sort of intrigues me here, though, which is, okay, so we all agree the first minor misdemeanor should be dismissed, there's no jurisdiction. Then we've got the second minor misdemeanor. Do you have to have, there's an admission to sufficient facts on the second minor misdemeanor, right? Mm-hmm. Do we need to have a Wallace W. hearing on the first one to do that one? How does that work?
I would suggest we should not, that it's a,
That's a little inconsistent with what we've said about we need you to prove something before you can prosecute and record a minor misdemeanor.
wouldn't that quaff count? Wouldn't that be the proof if there was already,
No, that's the second one. You see,
you're
I'm
going
trying
back to the first one?
Given that we keep getting these, and we're going to get the next one, I'm trying to anticipate it a little bit here and make sure I understand what you're arguing.
Mm-hmm.
So, again, the second, let's take a hypothetical.
Okay.
The first time he does this minor misdemeanor, everyone agrees it should be dismissed.
Yes.
You now have said you can have a second minor misdemeanor and admit to sufficient facts without having a Wallace W. hearing on the first one. That's what I thought you just said, or maybe not.
No, but that the quaff on that second one would count going forward.
Okay, go ahead.
I think, so perhaps maybe this will help, because I see Justice Kafker's concern and Justice Wolohojan's. So let's move this case forward, the initial quaff that we're talking about, the A and B.
Yes.
Let's put it not at historic Wallace W., let's put it post Wallace W. So when that first A and B came in, it just got dismissed, okay? That minor misdemeanor gets dismissed. Now you've got this 2-count delinquency complaint with the minor and the major misdemeanor. Nothing's been done here. In our case, it's different. There's been a quaff on this A and B. Assume that this case just got jurisdictionally put out because Wallace W. says it's his first minor misdemeanor. So now on this combined complaint where you've got the minor and the major, there's never been a prior adjudication. So can there be an adjudication on that minor misdemeanor if that A and B hadn't been adjudicated in the Wallace W. hearing? Or does the court have to stop and say, before anything happens on this minor misdemeanor, Commonwealth, you've got to go back and have a hearing on that dismissed out prior minor misdemeanor?
But in that situation, the first assault and battery isn't a minor misdemeanor, it's a major.
Just assume
So if
that-
it was a
if-
trespass.
Oh, yeah, assume that it was a minor misdemeanor.
Okay, so the first one is a minor misdemeanor, so say it's not assault and battery in Wareham, it's trespass. And then he comes to Barnstable Court and has the assault and battery and disorderly conduct. I would still think the quaff on that,
It hasn't been quaffed.
oh, it's still open? No, then he's entitled to a
No, it was
Wallace.
dismissed. The trespass was dismissed.
Trespass was dismissed, so then yes, he's entitled to a Wallace hearing for the disorderly conduct.
Okay, so what you're saying is, just so I'm clear, if we didn't have a situation where that first minor misdemeanor was adjudicated in some way and it was dismissed out under Wallace W., subsequently, like we have here, if you've got the minor misdemeanor and a major, that he would be entitled before that it can be an adjudication on the minor misdemeanor, that the Commonwealth would have to go back and prove that other one that's only in mass courts, that only the Commonwealth knows about and the clerks knows about, and prove that one before there can be an adjudication on the subsequent one.
I think there's that possibility, or there's the possibility, which I think with the splitting of the minor and major misdemeanors in Manalo, that it tracks behind, so that on that day at the arraignment in June, what we should have done was arraign him on the disorderly conduct, and then arraign him on the assault and battery. That disorderly conduct should have tracked. We would have resolved that assault and battery, and then would be left to resolve that disorderly conduct. That's also the procedure that's at play. It's not great, but it's a little bit more efficient.
Can I ask you a related question to Justice Wolohojan's, one of the options that she gave your sister? My view of this, and perhaps I'm wrong, is that we have the audio of the proceeding on the A and B quaff. You're going to get us a transcript. You're going to get us the tender of plea. I would assume that in this circumstance, a remand wouldn't be necessary because we'd have everything that would be in front of the juvenile court in terms of whether or not that prior A and B was proved beyond a reasonable doubt.
Correct. My understanding is we did, the Commonwealth did seek those things, and that the tender was not available, and we were only given access to the FDR within the past week.
Okay.
But yes, that you would have all those things and be able to look at it.
I would
as
think
whole.
that the tender could be, I would think that would be available, and that would be nice for the court to have that.
We hope.
Can you address the sufficiency
The sufficiency
of the evidence?
in regards to the original case?
The case that's, up here, the evidence on the disorderly conduct charge.
Yes. The evidence in regards to the disorderly conduct, I think, kind of loops back into whether or not, there was a self-defense instruction, the judge instructor herself read those things. I would suggest self-defense fails. So there was no legitimate purpose for his behavior inside the courthouse, and it was certainly disorderly, certainly disrupted. As you see in the video, which I'm sure you have seen, the juvenile comes up the stairs, essentially chasing the adult. That's disorderly in and of itself, chasing the adult, and then the physical altercation, and then the melee that ensues right in the beginning. That if there's no self-defense, if that's not a valid claim, then he is delinquent of disorderly conduct.
Does the sufficiency turn on the judge's finding of the defendant's mindset when he was coming up the stairs? The judge made a finding that he was essentially looking for a fight.
Yes.
It does turn on that.
I think yes, it turns out that.
And what was the evidence to support that finding?
When you look at the whole video, you see first the adult coming up the stairs. You see him come up the stairs, you see him look down. It appears that there's some conversation, and it's 2 seconds later that the juvenile comes right up the stairs. And you can see in the video, it's a short set of staircases. I think it's about 8 or 10 steps. There's one that goes down and then goes down here. There's a hallway here. You can see that all in the video. This was a continuance. This wasn't the adult laying in wait upstairs, which when you read the facts that the juveniles put out suggests that the adult was laying in wait. He came up the stairs, was surprised, and that's what happened. That's not it at all. The video, when you watch it, shows that he comes up the stairs. This is a continued progression from what happened downstairs. The juvenile is running in to an issue and then claiming self-defense, when in fact it would perhaps be Mr. Almeida, the adult, who would have had the better claim of self-defense.
Was there evidence that there had been an incident downstairs?
I
That
believe
this
when
was
you-
a continuation?
When you see the timing of the video and the timing of those two individuals coming up, I would suggest that that's where that suggestion comes from.
I could see that an inference that he was following him up. I couldn't really see how the video gave rise to a reasonable inference of what had happened downstairs.
I would suggest it's him leaning over the stairs, not just coming up the stairs minding his business, but looking behind him, leaning over and looking down into that below, and that the child comes up just behind him. I think it's about 2 seconds.
And what do we do with the fact that the first person up the stairs, at least on the evidence that we've got, which is the video, threw the first punch?
It's because he's being pursued by the other child, that he's coming right up behind him. He's taking the stairs 2 at a time. He's running up the stairs. And that's how that unfolded, that he came right, he was confronting, the child was confronting the adult at the top of the stairs.
But the video is very clear that the adult at the top of the stairs is behind the doorway. You can see the juvenile coming up quickly up the stairs. The adult is behind the doorway. He puts up his sleeves like this. He pulls up his pants, and he goes like this. I mean, and then as soon as the juvenile appears, you see the fist. I mean, it's not, are you arguing that the juvenile is the first aggressor in this situation?
I would suggest that from the point of view of where that is, that in fact he can see him when he's coming up the stairs. He's following him, he knows he's right there.
I thought your argument was just that he did not retreat where he could have.
The child, he did not, but he also didn't need to run into the situation. He was following, there was an issue as they went up the stairs. So so it's both.
But I understood that was a retreat argument, that he should have not have come up the stairs at all, not an argument that he was the first aggressor in the situation.
I think it depends on whether or not when you look at the evidence that the court was presented, whether you think self-defense was an instruction that was warranted at that point.
Well, do you need him to be the first aggressor, the defendant, in order to win on self-defense?
No.
Okay.
If nothing else, the Commonwealth would rest on its brief. Thank you.